This is Reasonable Doubt with your hosts, Mark Garrigus and Gary Smith.
Well, welcome to the Sunday edition. A little late, but by the way, we also missed one. We didn't go to church last Sunday, did we?
We sure didn't. Both of us were traveling, and it just was a little too crazy, and it's been far too long, Mark. It's great to see you, especially on a Sunday morning.
It's great to see you, too. And boy, what a week, huh? I guess we could brand this episode the SCOTUS, the end of term SCOTUS bonanza, right?
Yeah.
I don't even know which case to begin. Actually, I do, because I will tell you, for whatever reason, the affirmative action case was the one that kind of caught my fancy on Friday, to the point where, to show you what a legal nerd I am, C-SPAN was replaying the audio of the oral argument, and I actually spent hours listening to it yesterday. So do you want to summarize what the opinion says and the name of the opinion? I think it's...
the opinion is the affirmative action one is Department of Education v. Brown. Does that sound right?
No.
Okay. Let's see here.
You'll find it. And basically what it does is, it says that you can no longer, the Supreme Court has said, after there were two cases, Bakke, which came out of the University of California system, and Grutter, which kind of amplified Bakke, which said that to remedy past discrimination, that you could use as one of many factors race and to tip the scales, so to speak. And Gary's going to just pipe in when you find the name of the case.
I believe it's Students for Fair Admissions, Inc. v. President and Fellows of Harvard College. Does that sound right?
Yeah, I think that's the name of it. And it's an interesting case for a variety of reasons. Number one, it guts decades worth of jurisprudence. And although, and we'll get into the weeds in a second, part of what was fascinating about listening now to the oral arguments and then looking at the opinion cites, Gary, I just asked you to look it up and you found it. Can you give a synopsis of it? It cites the fact that in 1922, the then president of Harvard, what's his name?
Abbott or Lawrence Lowell. Right.
Interesting that Harvard has got affirmative action, because what was brought up during the oral arguments by Alito, Gorsuch, and actually one other, and Seth Waxman, who was arguing for Harvard. And boy, if you like oral advocacy, this couple of hours was spectacular. The Solicitor General, and I forget her name, she was just great, arguing for on behalf, basically aligned with Harvard. The plaintiff's lawyer had a command of the facts and the record that was just, it was wonderful to listen to. And Seth Waxman is really, really one of the elder statesmen of the Supreme Court bar, and was outstanding as well. It was just great oral advocacy. And basically, the justices, you could tell from the oral argument the things that bothered them. One of the things that bothered them is that, and this bothered Alito. Alito says he went back to look at one of the previous Supreme Court cases, and nowhere did anybody bring up the fact that the president of Harvard in 1922 was complaining about the rise in Jewish admittees and Jewish attendees of Harvard. And as it turns out, Gary found exactly what he was referring to. Can you want to summarize it there, Gary?
According to then Harvard President Abbott Lawrence Lowell, excluding Jews from Harvard would help maintain admissions opportunities for Gentiles and perpetuate the purity of the Brahmin race. He proposed limiting the quota of Jewish students to 15% or lower, and other American and Canadian universities followed suit.
And they hung that around Seth Waxman, presumably because he's Jewish, who handled it, I thought very deftly, and stated unequivocally how repulsed he was by all of that. But then there was a exchange between Waxman and the Chief Justice, where the Chief Justice was hot. And if you've listened to some of these Supreme Court arguments before, he generally is not. He's almost unfailingly very gentlemanly in how he approaches things. And he was talking with Waxman, and he was saying, if you have two identical students and one is African American and the other is not, and all other things being equal on the various categories and factors that they use for admissions, would the African American student get in at the expense of a non-African American student? And Waxman's response was something to the effect of, yes, that would probably tip it, just like if you were an oboe player, an accomplished oboe player, that would tip it. And Robert shot back, we're not talking about oboe players. We didn't fight a civil war over oboe players. I mean, it was really kind of a hot bench, if you will, and an interesting insight into which way they're going. In retrospect, listening to the oral arguments, it seems infinitely predictable that they were going to go there. Another subtext of what they were talking about is how long can you keep the affirmative action going, where it's one of the factors that tips the scale, because obviously you're trying to remedy it, and aren't there other ways to do that? Interestingly, for the UC system, that was kind of held up. The University of California system was held up as kind of a model that Harvard had not gotten to that point. And they started talking about legacy admissions and athletes admissions and things of that nature. All in all, I know that this is being heralded as the death knell for affirmative action and for redress. But there are things that I think, when you listen to the arguments and read the opinion, that you can make a compelling case, or a persuasive case. I don't know if I'd call it compelling, persuasive case, that there is an expiration on trying to remedy here. And I think that's at least a couple of the justices said that. Justice Kagan's arguments were spectacular as well, and her questioning, I should say, that her questions are arguments in interrogatory form, and also a former Harvard professor. So anybody, if you're interested in this, I would go back and listen to the audio of the arguments, because it's fascinating to me.
What is your reaction to the response that has come out from Harvard and has been, lauded on social media? I'm not sure if you've seen this, but basically they're clinging to a section of Robert's writings that says nothing in this opinion should be, quote, nothing in this opinion should be construed as prohibiting universities from considering an applicant's discussion of how race affected his or her life, be it through discrimination, inspiration, or otherwise. Harvard has come out and basically said, we like that language and we'll absolutely continue to consider their discussions, surrounding this. I think
that fits with kind of the Gorsuch model, if you will. My guess is that was probably when they were collaborating on putting together an opinion. By the way, my 3-3-3 model only didn't work here because Justice Ketanji Brown recused herself, which is interesting because under a wide, expansive view of recusal, you would think that Justice Kagan might have recused herself as well. But what they're saying here is, if you can say that the discrimination is individualized, or I have had a individualized experience that affects me based on discrimination, that can be a factor. And they said this in the oral arguments again, the mere fact of skin color cannot tip the balance versus somebody else. One of the other kind of subtexts of this is this African American Asian dichotomy, because the plaintiff was arguing that Asians were being discriminated against. It was reverse discrimination because, interestingly, they as a group statistically, and I don't think it was a large statistical variance, but we're being downgraded on what was called personnel or personality or characteristics, although they were statistically represented on extracurricular activities, which is an interesting thing. And I noticed on Twitter today, Jamel Hill was arguing with some others, or tweeting, I guess, with others about the African American community. And she was citing to various studies involving Malcolm X and several others about the affinity of the civil rights movement for Asian Americans and African Americans. But now this is being cast in some quarters as an Asian versus African American fight. And that's one of the subtexts here. And basically, if you listen to the oral arguments again, you will see that they were asking all kinds of questions as to why it was okay to discriminate in the sense that you get less points on this kind of convoluted a logarithm that Harvard uses if you're Asian than if you're African American.
Right. So the other big news out of the Supreme Court this week, I would say, comes out of Colorado, wouldn't you say?
Yeah, I think it's too bad we should have had Adam call in from Vegas, because he would have loved this one. The web design case, I assume. You want to summarize that? Yeah,
303 Creative LLC versus Alenus. The Supreme Court ruled that the First Amendment prohibits Colorado from forcing a website designer to create expressive designs for same-sex marriage, speaking messages with which the designer disagrees. It involved a website designer who refused to create a website for a same-sex wedding, citing religious objections. Colorado Civil Rights Commission found that the designer's refusal violated the state's anti-discrimination law, and the Supreme Court reversed the decision, holding that First Amendment protects the designer's right to refuse to create expressive content with which he disagrees. This has been a hot button issue, especially in the last 24 hours, I would say, on the left and on, the left side of Twitter, because apparently the person who was cited in the case has come out and said that he never made such a request and has been married to a woman for over 15 years. So now those on the left are, really, waving this flag on all the Sunday morning TV shows that this should have never been heard, and there's a lack of standing.
I want to go back a bit, because I understand the lack of standing is, and I invoke this argument, you can't ask a court for an advisory opinion. You can, that's, you generally, there's exceptions to that, but as a general rule, courts are not in the business of issuing advisory opinions. However, go back for a second. The Colorado state, was it their version of
the Civil Rights Commission is, I believe, what it's called.
Civil Rights Commission. I would want to know, and I'm not in the weeds on this as much as I am on the affirmative action decision, but why is the Civil Rights Commission involved? Why are they ruling on something that what people today, this morning, are arguing is not a live controversy? If they are involved, if that's true as reported, if they are ruling on the controversy, and if they are finding that that is a violation, then that is a controversy, case over. So I would maybe this week we'll go down that rabbit hole, because that's an interesting, I would want to know those facts before I just blindly say or accept the fact that it was not a live controversy.
Well, you're the only one who seems to be wanting to dive into the facts, because I've seen the exact same take from about 12 people this morning on various talk shows. But
well, I understand it's a great kind of gotcha if it's true that this guy who was cited is number one, was not trying to have a gay wedding, was already in a marriage, and that it's that basically the allegation is fabricated. However, if it's also true that the commission found it was a violation, discrimination, and under the Colorado law, then how do we get to that? What were they ruling on if that's the case? So I'm sure I've got a couple of friends in Colorado. I'm sure after this episode will get me up to speed on that.
Yeah, absolutely. I think it's important to dive in and know exactly what we're talking about, as opposed to just spewing the soundbite that is easy and fun to talk about. One more thing from the Supreme Court was a more surprising, I believe, opinion where they ruled for Alabama having to redistrict. They ruled against a map that they said was disenfranchising to black voters, and that one split 5-4, sort of with unexpected Kavanaugh and Roberts joining the majority.
Somebody tweeted at me yesterday, and it was a fantastic statistic if it's true. Kavanaugh is number one in terms of being in the majority. So when you talk about a swing vote, it appears that Kavanaugh is the leader on the leaderboard as a swing vote. That was surprising, but I'll tell you the one that actually surprised me more was the independent state legislature theory, which was, if you've got that, how did that split down? Because that was out of North Carolina. This is one we've talked about before, where I had thought that the reason they took this, and I'm wrong, was I thought they took this to rule that the state legislatures could, independent of the state Supreme Courts, they had kind of autonomy when it came to federal elections. The court did not rule that way. If you've got that case up there, Gary, let's get the site and the holding.
Yeah, it was by a 6-3 vote with Roberts in the majority and Kavanaugh and Amy Coney Barrett, along with the three liberals on the court, Justice Sotomayor, Kagan, and Brown Jackson, all coming together. Let's see here.
By the way, that's back to the 3-3-3.
Yes, it is. Yes, it is.
And that's interesting because we had talked about years ago for the 2020 election that part of the theory was, and part of what is being in the news now regarding Trump and Georgia and Trump and Arizona, is that he was trying to get the independents, the states, to send alternative electors from the legislature. And the reason for that is, I believe in 2020, that 26 of the states were Republican controlled. And so even if you won the popular vote, if you were Joe Biden, even if you won the electors, if you were Joe Biden, if the legislatures in those states basically sent a alternate slate, the argument here is that the state legislatures were independent and could do that, and there would be no redress by the independent state Supreme Courts. When they took that, I thought, well, here you go. This is going to be a theory that's percolated around for the last number of years, and maybe it's going to have some legs. It did not. I mean, interestingly enough, as you said, Kavanaugh, Roberts, and Amy Coney Barrett were not buying what they were selling, and that has great ramifications for the presidential race in 2024.
Yeah, and I think that's important that they got that out of the way before we really get into the full swing of things there. Have you seen the news that's come out in the last 12 to 24 hours that apparently Ro Khanna and another congressman are introducing a bill to set term limits for the court? I don't think there's going to be much traction there, but I thought it was an interesting piece of political maneuvering given the recent rulings.
And I also read this morning that I think it was on the Hill. There was an article about that there is a world in which this week's Supreme Court hearings, coming on the heels of Dobbs, will give wind to the back in the Senate Democrats for 2024. I think there's something to be said for that. And, I know it's an old saw, but elections have consequences. If you're interested in the Supreme Court makeup, then you need to have a president or who can make the appointments you want. And if you are worried about a Republican president, then you need to have a Senate who can be a backstop. Otherwise, yes, elections have consequences if the elections are fair and everything else.
Yeah, absolutely. And I think that this wave of Supreme Court, decisions is kind of waking people up to the importance of those things, and in a way that maybe they weren't paying as much attention to in some recent years.
Yep, exactly it. Now there's an interest, I've been on my soapbox for decades about special counsels. Do you have a video of the interview with Trump's former lawyer? And I'd love to set that up if you've got it.
I do. Go ahead and set it up, and it'll be up on the screen in a moment.
This is the interview you're going to see is with a lawyer who represented Trump, who supervised the searches by DOJ.
His name is Tim Parlamore.
And he also
Parlator, sorry.
Yeah, supervised, I believe, New Jersey, Mar-a-Lago, and Trump Tower. And in this interview, he, you may remember, if you're a detail-oriented, that he resigned upon the indictment and as Trump's lawyer. And I say that, and I kind of feel his pain. I remember when Michael Jackson was indicted 20 years ago. I immediately brought in Ben Brofman as another lawyer because I knew that the indictment, I would end up being a witness, and I was twice. So he resigned, but he's got some fascinating stuff. And so indulge me and play this.
Pursuing an indictment or ultimately a conviction as opposed to pursuing justice?
We have no evidence. I have no evidence that the special counsel is engaging in prosecutorial misconduct. I know there have been allegations made by the Trump team.
I watched it personally.
Okay, what did you see?
I saw them personally when I was in the grand jury committing misconduct of asking improper questions, trying to pierce the attorney-client privilege, and then improperly suggesting to that grand jury that the invocation of constitutional rights is evidence of guilt. That is absolutely misconduct. It's the kind of thing that in any trial, the judge would declare an immediate mistrial, and that prosecutor would be facing disciplinary charges. So I hope that when this is over, the prosecutor who did that will face disciplinary action.
Whose privilege were they trying to pierce? Yours?
The president's.
No,
Yep.
I understand, but which attorney?
Through me.
So they were trying to get through your attorney-client privilege?
Yes.
So was this during the sealed proceeding?
This was during my grand jury appearance.
Remind me why you were before the grand. I know.
I was there to talk about the searches that I had organized and oversaw, which is all of the the ones we spoke about are Bedminster, Trump Tower, the second Mar-a-Lago, and then the downtown Palm Beach ones. And even though I was there for that very specific purpose, they kept trying to go into totally impermissible areas. And when I refused to answer those questions, they would turn and make totally impermissible statements to the jury.
And how did the judge respond?
There's no judge in the grand jury.
That's right. Sorry, I forgot. This wasn't the sealed proceeding.
Hold on for 1 second, Gary. That's my favorite. That's my favorite question. How did the judge respond? We're in a grand jury where the prosecution's. What a great question. Anyway, go on.
No, that's pretty much the end of the clip. It cuts off.
So this is if you're a criminal defense practitioner. This should send chills down your spine. If you believe in the Constitution, it should send chills down your spine. This is the lawyer who is supervising, who is working with DOJ cooperatively on or at least presumably cooperatively on the execution of searches in a kind of an uncharted territory. He does that, and then they drag him in front of the grand jury, by the way, which is outrageous. We should have him on, Gary, because I'd love to talk to him about that, the fact that he was actually in front of the grand jury. And then they start asking him things when they know in front of a grand jury that he's going to have to assert privilege. He doesn't. She asked another question that I'll just charitably call ignorant. Whose privilege were they trying to pierce? The privilege is held by the client, not by the lawyer. The lawyer asserts and defends against the intrusion into the privilege at all peril to himself, which is what he did. And then to turn around and make comments to the grand jury about the assertion of the privilege, which is your duty as a lawyer. When he talks about how prosecutorial misconduct, I can't, other than deep sixing Brady material, this is a close second.
Yeah, absolutely. It was a very interesting interview, the longer version of it, actually. It's 15 minutes long, and that was a great clip. But it's interesting to see him speak, because he's very no nonsense about it, and he maintains his composure, but he is clearly as fired up about the subject as you just were.
Yeah, well, I mean, if people don't understand this until they're facing it themselves. Then they say, what the hell? How can this happen? How is this America? This is one of the fatal flaws, improvised IED built into special counsel type proceedings. I mean, that's it. It's exactly why there should never be independent counsels or special counsels.
So I'm sure you've heard by now, and if you haven't, I can play it for you. The tape that CNN obtained of the former president speaking with an author who was writing a memoir about one of his former colleagues, wherein he references some classified documents that he's purportedly holding at the time. Any thoughts on that particular tape and what it means for Jack Smith's case?
Well, it's very interesting because the indictment that is in Florida already cites the incidents in New Jersey. And there's been all kinds of speculation about, well, are they going to indict him in New Jersey? Or for these? Those incidents are already cited. Go back and read the indictment. It's already referenced in the indictment that is present in Florida. So all of this rampant speculation about he's going to get indicted in New Jersey, unless there's something else we don't know about, that makes very little sense.
Yeah, I've seen articles saying that Smith has between 35 and 45 more counts ready to go if he feels that the case in Florida is not going the way that he wants. It's, that's been...
And by the way, why should we think that's a good thing? If the case doesn't go how you want, then you're going to shop it to a different forum. I mean, this should give people who believe in civil liberties and the Constitution a great pause.
Jewelry is having a big moment right now, and with hundreds of products popping up in your feed every day, it can be hard to find a brand you trust. Alex and Ani has been creating meaningful jewelry for over 20 years, designing pieces that connect you with all of life's important moments. With an emphasis on value, there's truly something for everyone. You might be most familiar with their signature charm bangle. This bracelet literally created the category of meaningful jewelry and had you stacking charms from your wrist to your elbow. This piece is an icon for a reason. Completely size inclusive, each bracelet is adorned with a symbol designed to tell your story and express your unique style. Beyond the bangle, you'll find stylish, affordable jewelry for every occasion, from classic pieces to bold statement looks. Don't know where to start? Alex and Ani makes it easy to unpack the trends you're after and sprinkle in your personality too. Each piece comes with a personalized message and meaning, truly making it the perfect gift. You can take comfort in knowing that you're shopping with a socially conscious brand as well. To date, Alex and Ani has donated over $60 million to nonprofits worldwide, connecting fashion and philanthropy in an easy, fun, affordable way. Visit alexandani.com right now to discover the confidence that comes with a perfectly accessorized piece of jewelry. Right now, Alex and Ani is offering our audience 20% off with code MIDAS at checkout. Again, head to alexandani.com. That's alexandani.com and use code MIDAS at checkout for 20% off your order.
All right. Well, we could keep going with Trump, and if that's your desire, feel free to say so. But you just said something about, that makes me think of the Menendez case where, you don't get the result that you want and you go shop it in a different forum. In this case, you just get a new jury and try it again. Why don't you tell us about the updates in that particular case?
So we talked about it this week with Megyn Kelly, Marcia Clark and I did. I actually welcomed being on that. I was saying to Megyn, I don't know if you've got one of those clips, Gary, you could show it, because one of the things that I enjoy about Megyn, besides the fact that she's whip smart, when she puts me on with Marcia, one of my I've said it to anybody who will listen. One of the things that about the Menendez case, having practiced in both jurisdictions, meaning the both LA Superior Court and Van Nuys at the time, was the fact that the institutional memory of what was happening is rare. There still are a couple of people in the LADA's office who lived it or at the time, which is gives me some solace. But I think I'd mentioned before, what happened in that case is particularly galling because everything was presented to jury number one before the same judge who presided over jury number two. Jury and trial number one, I should say, had two juries. Lyle had one, Eric had one. Interestingly, those jurors, and mind you, once again, I'll explain, they were the fight, if you will, the legal fight was over, is it murder? So the killings were done with malice, or was it manslaughter, meaning the malice was negated? The legal theory was imperfect self-defense, which they got an instruction. They were able to put on evidence. And between the time of verdict number one and trial number two, what happened? The O.J. Simpson trial. So having Marcia
the O.J. Simpson trial and a lot of press that, really put pressure on the DA in question.
Correct. And that DA in question was up for re-election.
Yeah.
Eric Garcetti's father, Gil Garcetti,
right,
who was DA. And do you have a clip that you can show? You don't have it?
Don't have one, sorry.
So I was just talking to Marcia, actually not on the podcast, but we were kind of reminiscing, for lack of a better term, about everything that was happening in that office. She, like me, knew everybody who was involved, all of the players across, and it was, it's hard to believe, but that was getting at the time as much attention as OJ was. And what happened in the second trial, and our big complaint, and we're going to dive into it because the judge has now issued an order, basically an order to show cause, but asking the DA's office to informally reply. DA's office is obviously taking this seriously. They just filed a request. Instead of having to reply in 30 days, they asked for 90. We don't oppose that because it's obvious they're taking this very seriously. What happened in the second trial was the judge basically invited the DA, David Kahn, who was trying it, who's passed away. I know him. I knew him at the time and tried cases against him, to withdraw their acquiescence to imperfect self-defense. Not only did he not take the bait the first time, but they went through the entire trial. The judge was cutting off and not allowing and excluding witnesses who had testified at trial number one about the abuse. And sure enough, did not give an instruction on imperfect self-defense, and the jury convicted. Now, fast forward to the writ of habeas corpus that we filed, you've now got another independent party who alleges that Jose Menendez, in a declaration under penalty of perjury, raped him when he was a young boy member of the boy band Menudo, and the letter that was written by Eric to his cousin, Andy Cano, which predates 8 months, the killing itself, which Andy Cano died. All of his belongings were kept by his mother and his Kitty, who was Kitty's sister. Mm-hmm. So everybody who always says, what about Kitty? Remember, Kitty's two sisters, Marta and Joan, have been fearless supporters of the boys, who are now men, in the last number of years, and are completely supportive of them being released.
Yeah, absolutely. And just because you were kind of being very eloquent there, I think the big news there is that in response to your writ of habeas corpus, now the judge is ordering that now DA Gascon's office, because he's in there now, has to respond and has to advise whether or not they investigated this and investigated it properly and put the right effort into it. And I think that's big news.
Yeah. And, I keep using the term and I hate it, but it's a cliche. I'm cautiously optimistic.
Absolutely. All right. There's still 4 or 5 different things on my list here. Is there any particular direction you'd like to go?
Well, let's take one more before we wrap it on the Sunday morning, the big show.
Okay. Well, I'm going to go with the one that you emailed me about that you definitely wanted to get into. And that is that it is being reported that Rudy Giuliani has offered a proffer and is looking to protect himself and try to avoid or limit the damage that he may be susceptible to from an indictment.
This is, I think this is big news, because to have somebody who was the former U.S. attorney in the Southern District, to have somebody who was on Trump's shortlist for AG, to have somebody who is this much of a consigliere of Trump during the entire thing, to have him roll, so to speak, if he's going to, should send shivers down the Trump defense team. This is the last person that I would have suspected would roll, and should be probably, especially given this idea that they're invading attorney-client privilege, and they're going to make the argument, obviously, that it's crime fraud, and then they're going to pierce the attorney-client privilege. This is big news. I know we're ending the show with it, but it really is big news if it's true. And my guess is that it probably is, given who's been reporting it, how it was reported, and that Rudy hasn't come out and disavowed it.
Yeah, absolutely. And a lot of people are also pointing to the fact that this is probably the first person that they've gotten any cooperation from who was in the, so-called war room on the in the hours leading up to the January 6th incidents, and could advise on some of the things that were said there, and maybe that could be used, by the January 6th committee as well. So that's it's big news for many different reasons, because you're right.
I will tell you, he was the one. By the way, I didn't just out of nowhere come up with the independent state legislature kind of theory of what they were doing years ago when we talked about it. The reason that I kept bringing it up here was because he was the one who was out there articulating this idea and articulating what he should do. And he was also not just articulating it, but he was going into court in the various jurisdictions in order to try to get this done and to challenge the various, in the various states, Pennsylvania, most notably. I mean, we talked about his interaction with the federal judge in Pennsylvania many moons ago. And so, yes, this is big news. And it's if it turns out that it's true, it's going to be a big deal.
Yes, it is. It'll be fascinating to see what kind of a nickname he gets, because Trump is obviously fond of the nickname. So we'll have to watch with interest and see if more comes out, and we'll keep you guys updated. Mark, thank you so very much for your time on a Sunday morning. We really do appreciate it. And I look forward
to Gary, and I miss talking to you.
Yeah.
So thank you. And thank you for all of those who listen.
Absolutely. And everyone have an excellent 4th of July. We will be back probably after the 4th, but please have a fun and safe weekend with your loved ones, and be careful with those fireworks.
Thanks for listening to Reasonable Doubt. Subscribe on YouTube at youtube.com/Reasonable Doubt Podcast.